So there are three levels of management. This top level management is also known as administrative management. So this administrative management or the top level management people, whether it is a managing director, chief executive officer or a board of directors, they are going to lose the power in the first stage. So it is going to fulfill the liabilities of the organization. So as they are going to convert into cash to fulfill the liability of the organization. There are few circumstances which lead for the compulsory liquidation of a company under Companies Act 2013. Hello everyone, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with session 1 of Unit 5. It's about a liquidation of a company. Here in this session, we are going with how exactly the company get liquidated. Okay, what is the procedure for liquidation? What exactly the concept of liquidation is? This is agenda of today's session. We are going with introduction and meaning of a liquidation, followed by types of liquidation, which are all the ways the company get liquidated, followed by the consequence of liquidation. These are the three topics that we need to cover in today's session. Meaning of liquidation. What is liquidation? Okay, so liquidation means closing down a company. Okay, so it is nothing but winding up of company. Okay, so to wind up a company, two things should happen. Okay, so one is we should sell all the assets of the company, and in the same way we need to fulfill all the liabilities of the organization. Okay, assets over liabilities. Okay, in an orderly and lawful manner. Okay, so it is a order process, okay, that we are going to learn further. Okay, and in the same way it is a lawful process. Okay, so whatever the things that is going to happen during the liquidation of the organization, it should be transparent, it should be lawful, it should follow the law, Corporate Governance and Companies Act 2013. It involves converting the company assets into cash. So they are going to convert assets of the company into cash. Movable or immovable property will be converted into cash for the fulfillment or the repayment of creditors. Okay, setting its liabilities and distributing any surplus among the members. Okay, so it is going to fulfill the liabilities of the organization. So as they are going to convert into cash to fulfill the liability of the organization, and if there is any kind of a surplus amount that is remaining after the fulfilling the liabilities, after repaying the liabilities of organization, okay, so the surplus amount will be distributed among the members based on the preference. It implies terms. Liquidation is a process of ending the business operations of the company and setting its financial affairs. Okay, so it is going to finally end the operations of the organization. Okay, finally end the financial affairs. Liquidation or winding up may be defined as, so it is a definition. Okay, so that has been given by Companies Act 2013. The legal process of which a company's assets are realized. It is a legal process. While realizing the asset, liquidator is the person one who is going to realize the assets of the organization during the liquidation time. Okay, so he is going to do in a very transparent way. It is going to do in a very legal and the formal way by the liquidator. Its liabilities are paid off. Okay, so after selling the assets, after evaluating the asset, they are going to sell the assets of the organization. Okay, the liabilities of the organization will be completely paid, and any remaining surplus is distributed among the shareholders based on the preferences. Okay, so the remaining surplus amount, if there is any kind of a surplus amount after fulfilling the liabilities of the organization, it will be distributed among the shareholders based on the preference, after which the company is dissolved. Okay, so after this process we can consider, okay, the company is completely dissolved. Okay, there is no existence of the company cannot run the operations in its own name. Okay, the company do not have any right to make any kind of a contract in its own name. There the company is going to completely end. Okay, they are going to remove the name of the company with the register of the company. Okay, ROC. Okay, so then the process will get end. This is the actual process of a liquidation. So here, when it comes in terms of a process of liquidation, we need to consider three things. Okay, one is valuation of assets and sale of asset of the organization, followed by fulfilling the liabilities of organization. After fulfilling the liabilities, okay, so they are going to share the surplus. So three-step process it is. Types of liquidation. when it comes in terms of types of liquidation, it has been classified into two categories: compulsory liquidation and voluntary liquidation. This compulsory liquidation, okay, so happens if a court pass any order regarding the liquidation of the organization, that we call it as a compulsory liquidation. So on what basis it is going to send the order? If organization is involved in any kind of illegal activities, any kind of a manipulation things that is going to happen in the organization, or the organization didn't follow the act that is meant to follow, that is Companies Act 2013. Okay, so in these circumstances, okay, the court can order an organization for close. For example, according to Companies Act 2013, okay, so the organization should maintain its financial statements. If the organization won't maintain financial statements up to 5 years, 5 consequent years, okay, so it have a complete authority to send an order for the liquidation of the organization, okay, or winding up of the organization. That order we also call it as a order of winding up. Okay, so here what happens? Compulsory liquidation happens. How exactly this compulsory liquidation is going to happen? Okay, say what happened? We already know if a company is involved in any kind of illegal activities, any kind of a manipulation kind of thing is going to happen in a company, then only the court is going to send the order or send the notice for the company for the liquidation. Okay, the order of liquidation or the dissolution. Okay, say what happened? Let me say A company limited, okay, had involved in illegal activities inside the organization. Okay, so what happened? As soon as they catch hold of this kind of cases, they are going to call for a hearing. In the hearing, they are going to investigate the case. They are going to decide who is responsible for the cause. And in the same way, so finally that they are going to decide for the liquidation. They are going to conduct a hearing. They are going to investigate a case. Okay, finally they are going to decide for the dissolution of the organization. Finally, they are going to send the notice of a liquidation. As soon as they send the notice of a liquidation, okay, to the concerned authority, which is responsible for the liquidation, okay, so the central government is going to appoint the liquidator to liquidate a company in a lawful way, in a transparent way. Okay, so here the liquidator come to existence. Okay, he will be having all the power to liquidate a company. First thing that he is going to do is he is going to take all the documents that is relevant for the assets of the organization. He is going to consider all the liabilities of the organization apart. He is going to take charge of all the documentation, all the documents which generate the income. Okay, so all the things will be taken over by the liquidator. He is going to evaluate the complete assets of the organization over a liabilities. Okay, so he is going to sell complete assets of the organization, fulfill all the liabilities. If there is any kind of a surplus amount remaining, okay, he is distribute among the members lawfully. Okay, so that is a process which is going to happen in the compulsory liquidation. Here in the members voluntary liquidation, here this is not the process where it is going to happen. Voluntary liquidation, members voluntary liquidation can happen. Okay, so if there is any kind of a issue that has been faced by the members of the organization, okay, so the people, if they are liable, if their company is capable of fulfilling the liabilities of the organization, then this can happen, the members voluntary liquidation. But when the company is liable to or capable of fulfilling the debts of the organization or the liabilities of the organization, even this is also going to happen. But in this term, okay, the company is capable of fulfilling the liabilities, but there may be any kind of issue. For example, they couldn't able to cope up with the changes. They couldn't able to manage the entire company, this kind of thing. Okay, so in these cases, the company come to an end. Okay, so that we call it as a members voluntary liquidation. Voluntarily, the members, that is the directors of the organization, decide for a liquidation. Next one is creditors voluntary liquidation. If a company couldn't able to fulfill the liabilities of the organization, okay, so then they are going with the creditors voluntary liquidation. Okay, so there what happens? Okay, so creditors are going to claim against the company. Okay, so after they claim against the company, they are going to evaluate the complete assets of organization over liabilities. Okay, so the company is insolvent. In terms of company is insolvent, they are going with the creditors voluntary liquidation. The company is solvent, they are going with the members voluntary liquidation. If a company couldn't able to fulfill the debts of the organization, okay, so they are going with the creditors voluntary liquidation. So in this process, the meeting of creditors will be conducted. based on the preference. Okay, so in this process, the secured creditors will be served first, followed by the preferential creditors, and if there is any kind of surplus amount remaining, they are going to distribute among the unsecured creditors. Okay, so this is the actual way how exactly the liquidation happens in the company. Okay, so moving forward, consequence of a liquidation. When it comes in terms of a consequence of a liquidation, how exactly the liquidation is going to happen. So as we know, there must be a base for the liquidation, whether it is a voluntary liquidation, whether it is a compulsory liquidation. Firstly, the cessation of business. Okay, so when it comes in terms of a cessation of a business, firstly, the people are going to lose the power, that is the top level management. Okay, so as explained in the previous session, okay, so there are 3 levels of management. This top level management is also known as administrative management. Okay, so this administrative management or the top level management people, whether it is a managing director, chief executive officer, or a board of directors, they are going to lose the power in the first stage, followed by transfer of control. They are going to transfer the control to a liquidator which has been appointed by the court. Realization of assets. What exactly he is going to do? He is going to realize the complete assets of the organization, because all the power is given to the liquidator, where he is going to have all the documentation which is relevant for the movable or immovable property, whatever the property or the asset that is been there for the company. Okay, so that he is going to realize the complete asset. He is going to take the value, take the worth of the complete assets. In taking the value of the assets based on the depreciation, okay, so based on the bidding or based on the personal selling that they are going to consider, and value will be calculated. Payment of liabilities. Okay, after taking the value of the asset, okay, after the sale of the asset, they are going to fulfill all the liabilities of the organization. So the liabilities of the organization will be paid on the basis of the preference. Okay, so firstly the secured creditors, followed by preferential creditors, and if remaining amount or the surplus amount will be distributed among the unsecured creditors. Effect on employees. See what happened. Okay, the liquidation is going to happen. Okay, so according to Companies Act 2013, they must give compensation for the employees for this cause, because all the employees are going to lose the job. Okay, so these employees have all the right to claim the unpaid salary amount, unpaid allowances, unpaid dues that is should be paid by the organization. And in the same way, the organization must pay some compensation for the people for their survival and growth. Followed by legal proceedings. Legal proceedings, completely the official kind of thing that they are going to consider the books of accounts. The tribunal is going to consider the books of account. Okay, while distribution of the liabilities of the organization. Okay, so it should be maintained. Distribution of the surplus. Okay, so after they maintain the account, okay, that books of account will be submitted to the tribunal. Okay, after that, distribution of surplus. What is if there is any kind of a surplus, this surplus will be distributed among the members of organization. Finally, the dissolution of company. Dissolution of company is nothing but, okay, so as I explained, while forming a company, formation of the company, they are going to register under ROC, register of the company. So they need to remove the name from this ROC. They need to send the official notice to the public saying that this company will be closed. They are supposed to mention in the official website. They are supposed to give the report for the SEBI. So these are all the kind of things is going to happen at the last stage. Okay, so that we call it as a winding up of company. So the moment they remove the name from ROC, there is no legal existence of the company. The company get completely wind. The company cannot run its operations. Okay, the company cannot make any kind of a contract with other people. Okay, so then the company is going to come for a complete end. Okay, so this is a process or a procedure which is going to happen. The next section, we are going with the appointment process of a official liquidator. Who is the official liquidator? As I said, official liquidator is a person which is appointed by a law for a liquidation of the company. Okay, so he is the one who is going to compare, okay, so sell complete assets of the organization for the fulfillment of the liabilities of organization. The duties and the responsibilities of a liquidator. What exactly the liquidator is going to do when it comes in terms of liquidation. So these are the things that we need to go with next session. Thank you.